We'll hear argument first this morning in Case 12-1281, the National Labor Relations Board versus Noel Canning. General Verrilli.
Mr. Chief Justice, and may it please the Court, the interpretation of the Recess Appointments Clause that Respondent urges would repudiate the constitutional legitimacy of thousands of appointments by presidents going back to George Washington. And going forward, it would diminish presidential authority in a way that is flatly at odds with the constitutional structure the framers established. Respondent simply has not advanced the compelling case that would be needed to strip presidents of their traditional authority to make appointments during intra-session recesses and to fill pre-existing vacancies.
You say that it would repudiate the constitutionality of appointments. You don't suggest that the actions of those appointees would be invalid going back however far you want to go back, do you?
No, I don't, Mr. Chief Justice, but it certainly would repudiate the legitimacy of those appointments.
How did it affect how many board decisions will have to be redone, or how is the board coping with that problem?
Well, there are many dozens of board decisions and perhaps many hundreds of board decisions that are under a cloud as a result of the D.C. Circuit's ruling in this case. And so the board will have a considerable amount of work to do if the D.C. Circuit's decision were to be affirmed.
Mr. Chief Justice, and may it please the Court, the Advice and Consent Clause imposes an important check on executive power. Each of our three arguments preserves that check and provides a separate and independent basis for affirming the Court below. The government's position, in contrast, would eviscerate that check, creating a unilateral appointment power available for every vacancy at virtually any time, with advice and consent to be used only when convenient to the President.
But your argument would destroy the recess clause. There would be, under your argument, it is totally within the hands of the Senate to abolish any and all recess appointments.
Yes, Your Honor, and that reflects the fact that the recess appointment power is a contingent one. It arises only when the Senate chooses to trigger it by ending its session and beginning its recess. So the Senate always has the power to prevent recess appointments. The Constitution, however, gives the President corresponding powers. If the President thinks that the Senate is being derelict in its duties, he can convene an emergency session and he can force the Senate to consider his nominees.